Well, if the dispute is taking place in the Irish courts, the only way in which the Court of Justice can get involved is if there is a reference by the Irish courts to the Court of Justice under Article 234 of the EC Treaty. And that effectively is a legal question or questions posed concerning the interpretation of the procurement rules to the Court of Justice itself. And typically the question would say, does Article X of Directive Y have the following meaning in a particular type of case? The questions can be slightly more involved than that, but that's fundamentally the type of issue. Or it could be expressed in the terms of general principles. Does the principle of transparency or whatever general principle is at issue require that X be done or Y not be done? That's the kind of level of generality at which the question is posed. The Court of Justice answers the question often in quite specific terms by reference to the individual case, but it doesn't, the answers don't in itself say, as a result, the plaintiff must win or the defendant must win. Rather, it gives binding answers which the Irish court would then be required to apply. And in a number of cases that have been thus referred by the Irish courts concerning the procurement rules to the Court of Justice, in one or two instances when the answers have come back, there has been further debate before the Irish courts as to the application of the answers to the facts of the given case. Now, one other thing that you have to bear in mind is that the delay that is involved in a reference to the Court of Justice. Typically, the delay is of the order of 18 months to 2 years before the answer comes back from the Court of Justice. So that is a factor that also has to be taken into account. And I suppose I should add for completeness that the Court of Justice can sometimes get involved in Irish cases where a direct action has been brought by the Commission claiming that Ireland has failed to abide by its obligations under the procurement rules in the way in which a particular public law body or contracting authority has organised a particular or conducted a particular tender. When you've lost a tender, I think it is always useful to get feedback from the contracting authority, because sometimes that would help to dispel concerns or anxieties that you may have. And I think the courts will often expect that you would, as it were, exhaust such remedies as are available to you and that you find out, at least get a sense of why you lost. But I think it's also important to bear in mind that there are fairly strict time limits, and just because you have attended a feedback meeting doesn't mean to say that that in itself stops the clock. There's a decision from the Irish Supreme Court in 2003 called Decra Éireann, where the losing party attended such a feedback meeting, threatened at the time to seek an injunction restraining the award, were given access to certain documentation, were allowed to review materials concerning the award of the tender, then had a series of meetings with the contracting authority which ultimately proved inconclusive. But then, for their own reasons, did not commence the proceedings within the stipulated 3-month time limit. And the Irish Supreme Court refused to extend the time, saying that DECRA were fully aware of where they stood, or in general terms where they stood, that they hadn't advanced any reason why they hadn't commenced the proceedings promptly and in any event within the 3-month period. And therefore, when they commenced the proceedings, even a fairly short period after the 3 months had expired, they were invoking the discretion of the court, and the court said that delay in these sort of cases is rarely to be excused. So that puts, I think, the feedback meeting in context. Obviously, it's very useful to attend and to get a sense of where you went wrong or how you could have done better or what the feeling of the contracting authority was. But don't think that that in itself stops the clock, or that you can go away in a leisurely fashion, consult with your lawyers and then come back sometime afterward and say, by the way, we want to start legal proceedings. If you want to attend a feedback meeting, I think it's important you do that, for your own perhaps peace of mind and esteem, and putting certain concerns, allaying certain concerns that you might have. But if you are determined thereafter to go down the legal route, I would suggest that you do so immediately and don't allow any grass grow under your feet. In the context of public procurement, judicial review is the review procedure whereby the courts are invited by the disappointed applicant to either set aside the award, in some instances restrain the making of the award, and or award damages. But it's important to bear in mind that the courts are essentially the referee to make sure that the rules have been scrupulously adhered to and applied fairly. The courts don't have the expertise, they don't have the role in substituting their own judgment for that of the contracting authority. So that to all intents and purposes, all that the courts can do is to say that this decision was a wrong decision because the rules were improperly applied by the contracting authority. The rules being, I suppose, the rules being collectively the detailed rules contained in the procurement directives themselves, and then the general principles which inform the directives, such as the principles of transparency and non-discrimination and so forth. And that is what the courts are engaged in the review procedure. They do not second guess as such the decision of the contracting authority. Rather, they see that there was fairness as between all tenderers, and that the procurement rules, which are based on the idea of non-favoritism and equality as between equally situated tenderers, that these principles have been applied in practice. The Court of Justice has held that even in cases where the procurement rules and directives do not apply, such as, for example, you fall below the threshold or it falls into one of the exempted categories, that quite independently of the detailed procurement rules and directives, there are general principles of community law that apply to all tenders. These would include, for example, non-discrimination on grounds of nationality, to take an obvious example. But in addition, I think that there would be other general principles which would apply. The duty to abide by fair procedures, for example, the principle of proportionality, and I think the principle of transparency would also be applicable to all tenders, even if those tenders fall outside the rubric of the public procurement rules in the strict sense of the term. The Irish Freedom of Information Act of 1997 is a radical piece of legislation which has transformed the way in which the public at large can find out about the way government functions, and I'm using government in the broadest and widest sense of that term. And in my experience, in all realms of public life, persons who have had dealing with the government or government agencies have been particularly adept at using the Freedom of Information Act to obtain lots of practical information. And this is also true in respect of tendering and contracts of this kind. But it's important to bear in mind that there are limitations in the 1997 Act. One of them, specifically, deals with confidentiality, and there I think you will find that while the 1997 Act enables tenderers to obtain a great deal of information around the background to a tender, going beyond that, you come up against the confidentiality provisions, because the Act says that you're not obliged to release the information where this would effectively jeopardize, I'm paraphrasing here, but effectively jeopardize the running of competitions or tenders for the future. And obviously, if the contracting authority was obliged to make disclosure of sensitive information, and specifically commercially sensitive information, in the hands of the winning contractor, if it was obliged to do that, it would make life very difficult for the running of tenders for the future. With that important caveat and proviso, I think you will find that the 1997 Act has proved quite useful in getting background information and enabling potential tenderers to get a sense of what is really going on. But beyond that, you will find that getting details about the way in which a particular contract or tender was run, you run up against this confidentiality section in the Freedom of Information Act.